Started, and I would call on John Corbett to say a prayer for us.
Let us pray. Dear Lord Jesus, we come before you today, Lord, just we can know what you know how. I just thank you this day you've allowed us to see, Lord. Just thank you once that's here this morning, Lord. Just as we gather to do the business of the state, we just ask you just grant us a portion of that knowledge and wisdom wherever decision we make is pleasing in thy sight. All things asked in Jesus' name. Amen.
Amen. Lord,
Thank you.
For that rain, that man that's got that boat and got those animals getting in it. What's he up to?
Thank you, Representative Corbett. I appreciate that. Well, it is a beautiful rainy day in Georgia, and we do need the rain, so I'm sure God knows what he's doing. But anyway, we're glad to have you here today. If you do have a device, please silence it at this time. And we're here today to report on the findings of the House Study Committee. You'll remember that was House Resolution 743, and it was dropped so that we could develop a committee and evaluate the issues relating to local legislation and publish the findings of the committee by December the 1st, and we did that. The folks that served on that committee was me as chair, and we had Chairman Ed Reinders, Chairman Tom Taylor, Representative Mary Margaret Oliver, and Representative Beth Beskins. We covered a lot of topics. We had some very intense discussions, and we all learned a lot. And I tell you, it was interesting even to me, and I have a background in local government, city and county, but that there's really some significance, or a great deal of significance, to the timing of some annexation concerning budget adoption and property tax bills. And those annexations can occur, and they do occur after county budgets are implemented, but before the tax bills are distributed. And that can be a real challenge for a county, for a county's population, because it becomes less consistent due to changes in the boundaries of the city. So a county, you know what ends up happening a lot of times, a county may provide services for a portion of the year, but later they may not receive the tax revenue to cover the cost of the service delivery. So the annexing city is responsible for the public safety services like fire and police, but they may not have the resources available to deliver those critical public safety services at the time that the annexation takes effect. I'm sorry, can't even read right. But anyway, this really points to a need, I think, for intergovernmental agreements to provide those services. Another issue that popped up was school services that are also impacted by annexation and de-annexation, where independent and county school districts operate within a county's limits. Changes in city corporate limits can cause students to potentially move from one school system to another, and school system real estate assets could also be affected, and they are affected. So it was amazing to find out that current law does not allow school impact as a reason to object to an annexation. A school district can lose real estate property to annexation without compensation or time to plan and time to respond. So this study committee report describes the general problems that's faced by both county and municipal authorities, and it concludes by highlighting possible considerations that could resolve the varying problems that do arise when we're dealing with annexation, de-annexation, and the incorporation process. So to continue on our agenda for today, I'm going to call on Leo Chansey, our policy analyst, and he's going to give us a brief overview of the the study committee report, and I will call on you now, Leo, to move forward with that.
Thank you, Madam Chair. Members of the committee, if you look on page 6, basically is where it starts with the annexation section of the report, and we came to the understanding that municipality or municipal governments use annexation as part of a long-term growth and to accommodate or control urban expansion. There were several concerns that did arise for the legal notice of intention to introduce local legislation. that is published in the county legal organ, that it still does not provide enough time for residents, whether it's the municipality or on unincorporated areas, that this annexation is being proposed. As annexations do occur, Madam Chair touched on, it can affect county budgets that are implemented, and before the tax bills are distributed, the annexation can cause the county's population to become less consistent, and the county may be able to provide services for a portion of the year without receiving the budgeted tax revenue in order to cover the cost of the service delivery. Then again, on page 5, changes in city corporate limits can have an effect on the redistributing students and school real estate assets among city, county, and independent school systems. And under current law right now, an objection for an annexation does not include school purposes, or whether it's real estate or student impact. And for our recommendation for annexation, the chairman of the House Intergovernmental Coordination Committee has the discretion to create an annexation subcommittee, which would be tasked with the responsibility of handling any annexation issues, particularly any annexation that would affect a fiscal study, let's say, of a proposed incorporation. They have to do a study to see if it's economically viable, and if an adjacent city decides to annex a business district or industrial complex, that would definitely change the numbers, whether or not this proposed city could deliver the services that it's proposing. The other issue would be any delegation disputes or any delegation conflict. I can say that there are delegation rules that require a certification from the chairman, and there could be a delegation dispute where it does have the signatures required, but it doesn't have the certification from the chair. And so the subcommittee would report its findings and recommendation to the full committee, where we would have a hearing and a possible vote on the annexation to move on to the local calendar. Next, for de-annexation, while cities must be able to count on stable boundaries, de-annexation promotes self-government for citizens who are unhappy with their municipal services. The basic process for the de-annexation property can be problematic, especially for homeowners whose taxes have increased or restricted by city ordinances on how to maintain their property. There are other areas like that, but under Georgia law, a property owner cannot de-annex from a city unless it gets approval from the city governing authority. And so our recommendation was that the annexation and de-annexation process should be reflective. If you're going to allow the 100% method for annexation, then the de-annexation process should be similar. If 100% of the property owners wish to de-annex the city, they should be allowed to. Then in incorporation, there is no code section that dictates the minimum number of services offered for a newly incorporated city. The code section that is being used for the minimum of 3 services was only established for active cities that may have decreased the number of services they were able to provide. It wasn't used as a tool to create a new city and say, well, we're going to only have 3 services and create a new municipality. But when an incorporation of a new municipality occurs, the tax revenue related to that area no longer transpires to the county. And so all business licenses, insurance premium taxes, or other revenue is transferred to the new municipality, and these returns are crucially important to the county that is losing this revenue. And because we don't typically handle new incorporations, they usually go to the Governmental Affairs Committee. Our recommendation was that the concept of city light is not defined in Georgia code, but a clear standard may need to be further reviewed or for any future municipal services. And So that was basically our recommendation, mainly pertaining to annexations, for a subcommittee to be comprised of 5 members. And again, this would most likely come up in the next session after we adopt new committee rules to establish a subcommittee for annexation legislation.
Sure. With this, if you have an annexation, the existing loss and SPLOST agreements between the city and the county would transfer to the new annexation.
Right. Do you need to slide? Yeah, and I believe they would also have to have an intergovernmental agreement on where those revenues will take place, or if the county, could still maintain the services, or if the city's going to take over. One of the issues was with, for example, retirement or pensions.
Employee relations.
Right, exactly. So any county employees that are now being incorporated in a new municipality, who takes that? And so I think there is a proposal from, I believe, Mary Margaret Oliver, who has legislation only for DeKalb County, but that was another issue that was brought up.
So there's so much information in this report, and as it makes great bedside reading. There were so many issues raised that gave us all a lot to think about. The annexation process is somewhat complicated, in that if a delegation approved an annexation, the chairman signs off, it could come to our committee, and essentially all we're doing is making sure that all the technical requirements were met, like signatures and sign off by the chairman, and that just allows the local government to move forward with a referendum for an annexation. But during all the testimony from the public, we had public input at every meeting, and as I reported to you, we heard how severely impacted school systems are. In my opinion, it seems that local governments should do more, or the organizing, the folks that are organizing an annexation or a de-annexation should really dig a little deeper and report their findings along with their requests, because I think the citizens that we all represent across the state of Georgia think that we're looking into a lot of these fiscal impacts or impacts on the school, when essentially we could just go on the technical requirements and put it on the local calendar and let it go. So we've got a lot to consider, and I would appreciate it if you would devote some time and attention to this report and give us your suggestions and comments. And part of our, go ahead, Leah. Oh, we have a couple of questions. Okay. Member number 3, mic number 3. I'm sorry.
That's me.
Okay.
Thank you, Madam Chair. I think it was last year, and I don't know the whole situation. It's not my part of the state, but some part down in Valdosta, they wanted to annex or actually de-annex. I don't know what, Waycross, but something happened. But did your study look at, sometimes, if I look at a map of Georgia, some of the counties actually have some pretty crazy shapes. And if a county wanted to change its borders, is that allowed in law? And did you look at, what that process would be? And what happens that's, with something like that?
Well, if you're referring to what happened in South Georgia, there and that's in the. I mean, it's not specific to that occurrence, but there was some concern about the author of the bill making sure that impacted local governments are notified. When there's a proposal for annexation or de-annexation, there's the notice of intent that's published in the newspaper, and then there's an affidavit that each representative in the House signs. But we're fortunate in that today we do have Paul Higbee. He's been assigned to work with us from Legislative Council, and he's going to address a new affidavit and the why we're signing those, and we're saying that we are the author of the bill and we're responsible for making sure that the intent was advertised in the proper legal organ, and that involved municipalities or governing authorities is what I meant to say, have been duly notified. I think that's one incident that, after talking to several other House members that have been here for a long time, we've only had, this is the first occurrence that anyone can remember in 18 years. So it's not something that happens often. It's something we don't really want to ever have happen. But anyway, we've taken steps to make sure that there's, clarification on that issue. And we have another question. Okay. Okay, Representative Bentley.
Well, thank you, Madam Chair. That was pretty much what I was going to ask. I was just curious to know what brought about this study committee. So you pretty much answered that for
Well,
me.
it was not only on that one incident.
Okay.
It's just that we wanted clarification on every aspect of the issue of annexation, de-annexation, and, what the issues were that counties and cities were encountering and how we could better address them in this committee.
Okay.
So it was not at all due to one incident that occurred in a number of years.
Okay. Thank you.
You know what I thought was interesting, and to clarify, on the new cities that we're creating so many, or trying to in townships, that they don't have to have 3 of the services, when you mention that, because I know back years ago, remember when we did that, that was the big argument. We were consolidating so many and forcing them out of cityhood. Now we're letting them come back without the services, so
Well,
that kind of seems like an inconsistency, doesn't it?
Right, and you're exactly right. I did a little, researching into the history of that law, and I believe, if memory serves me correctly, and it doesn't always, that law came into being in 1995,
Right.
and it was introduced by, he's from Perry, Georgia.
And we made, yes, and
Yeah,
we made so
and-
many cities angry.
Right. Well, but that needed to happen
It
because
did,
the
it did.
services had some were not offering any services
No.
at all. But if you carefully read that law, it distinctly addresses cities that are already incorporated, and it
Right.
says that you must maintain at least a
Maintain.
minimum of the following 3 services. But by Georgia constitutional law, we can't limit a city in the number of services.
You know what
that
I'm
they
saying? But in
provide.
the new
You're
ones they're
right.
doing, they're not having to.
Well, so there somehow this term "city light" evolved.
Yeah.
I'm not sure where it
I
came
know.
from, but that code section was never designed
and we may have to
to deal with new cities.
deal with it, yeah.
So, okay. Any other questions?
Madam Chair, may I couldn't reach-
Please, representatives. You can't reach your.
No, but that's okay. I'll speak
Okay.
up.
All right.
First of all, thank you for starting a discussion on annexation, and I look forward to providing some of the comments because of the members. We had 2 from DeKalb.
Right.
So that it is, in some instances, not a full view of the unincorporated areas, because neither of those members are in the unincorporated.
Mhm.
But I voted for the annexation study because we need to start the discussion. So I look forward to adding some comments of the areas that are proposed in annexation and those in cities, how those impact from a wider area as it relates to the unincorporated areas. But thank you very much for taking the time to even start the discussion.
Thank you, Representative, and I look forward to hearing your comments. And you've been here for a long time, and you've experienced a lot of these situations that we're now trying to address.
I have. Thank you.
Thank you. At this time, I would like to call on Paul Higbee with Legislative Counsel, and if you would address our committee.
Thank you, Madam Chair. Good morning. Good morning, committee members. My name's Paul Higbee. I'm with the Office of Legislative Counsel. I was asked to speak briefly. I'll try to keep it as brief as possible. I know everybody's busy. This morning about the affidavit form and also the ad for local government legislation. I thought what might be a worthwhile endeavor would be for me to simply read through the statute. It's only 1 page, so that's not, don't get scared. But read through it with me interjecting some commentary here and there. I know this office has provided a very detailed, informative email to all the members. I don't want to go back over too much of that. You have copies, I believe, of the affidavit form and of our standard ad instructional language that I'm sure you found very helpful. That said, I'm just going to read through the actual statutory verbiage so that you can hear it and sort of take it in. Please feel free to stop me with questions if you would like as I go through. The section number is 28-1-14. Subsection A provides no local bill shall become law unless notice of the intention to introduce such bill shall have been advertised in the newspaper in which the sheriff's advertisements for the locality affected are published. I'm going to pause there and just point out, we all say the word probably legal organ. Well, we publish it in the legal organ. Statutorily, what that means is you find out where does the sheriff publish ads, and that's the legal organ. I know sometimes folks are confused about that. Okay, and that publication occurs one time, so just have to publish it one time before the bill is introduced. Such advertisement must not be more than 60 days prior to the convening date of the session at which the bill is introduced. And now, hearkening back for a moment to our ad form, we highly, highly recommend that when you're working with your local government authorities, you as soon as we can get you that ad form, get them that ad form. Try to impart upon them, please use that ad form. One reason for that is we tend to draft the ad language very broadly, narrow ad language. The problem can be you run the ad, you introduce the bill, you comply with everything, and then there's an amendment to the local legislation. And if the ad is specific and the amendment strays from what the ad talks about, you have to run a new ad. So you have to start that ad process all over. So we draft very broadly to avoid that from happening as much as possible. So can introduce it as early as 60 days prior to convening. After the advertisement has been published, and this is an important point, the bill may be introduced at any time during that session unless the advertisement is published during the session, in which event the bill may not be introduced before Monday of the calendar week following the week in which the advertisement was published. Okay, another point about using our office's ad form, something that can happen is local city or county attorney drafts the ad, publishes it, thinking, wow, I just got us ahead of the game, and then 4 weeks go by, as I will get to in subsection B. That can also present a problem and a requirement that the ad be run again. So if the ad runs within the 60 days prior to the session beginning, and you provide the notice that I'll talk about to the county or city if it's required in a moment, then you've got the whole session to sit back and relax and introduce the legislation. Also, if anyone is interested in thinking about a Christmas present for our office come about October of next year, it makes us very happy to get that local legislation as early as possible so that we avoid these problems altogether. So, and again, if the ad is published during the session, the bill may not be introduced before Monday of the calendar week following the week in which the advertisement is published. A question that can come up is, well, what if we publish on Sunday? Does that mean I've got to wait? I've lost that whole calendar week and have to go to the next one? Yes, you do. That is governed by OCGA Section 1-4-2, which provides that calendar weeks begin on Sunday. So if the ad publishes on Saturday, you can drop it on the following Monday. If it publishes on Sunday, you're going to have to wait that entire week until the following Monday. Subsection B, no local bill amending the charter of a municipality or A, the enabling act of the governing authority of a county or of a consolidated government. So 3 situations: city, county, consolidated government. If you're amending the enabling legislation, charter, whatever you want to call it, of that entity, then that shall not become law unless a copy of the ad, notice of the intention to introduce local legislation, required by subsection A of this code section, is mailed, transmitted by facsimile, or otherwise provided to the governing authority of any county, municipality, or consolidated government referred to in the bill. And here's where it gets tricky and goes back to please use our ad form. That notice if it's required, to the county or the city or the consolidated government has to be given during the calendar week in which such notice is published, or during the 7 days immediately following the date of publication of such notice. So again, the problem that can arise is city or county attorney runs an ad, 3 weeks go by, suddenly you're given the ad. Well, it's amending, let's say, a city charter. It's now too late to provide that required notice to the city. Even though you're thinking, well, the city attorney ran the ad, the statute says even if that's the case, you, the member, have to provide notice of the ad to the city or county, to the local government, either in the same calendar week or within 7 days of that ad running. A single notice sent by United States mail, postage prepaid, addressed to the governing authority of the county, municipality, or consolidated government at the official address of such governing authority shall satisfy the requirement of this subsection. If such notice is mailed, the notice requirement of this subsection shall be presumed to have been met by depositing a copy of the required notice in the United States mail. For purposes of this subsection, a copy of the notice provided to such governing authority may consist of an actual or photostatic copy of the published notice. So you take the newspaper, you put it on the copier, you hit copy. Or a typed restatement of the contents of such notice. So either of those will suffice, but within that 7-day period or same calendar week period, you've got to provide that notice, and you as the representative are responsible for doing that. Section C, and this is where the affidavit is discussed. A copy of the notice as it was advertised, and an affidavit stating that 1. The notice has been published as provided by this code section, and 2. That the notice requirements of this code section have been met shall be attached to the bill and shall become a part of the bill. Such affidavit shall be made by the author of the bill. And that's the whole code section.
This thing just haven't called you.
My question is this, and this was a discussion that came up in our city government, but that has not been revised for quite some time, I would guess, right? Because everything is by U.S. mail and no electronic reporting at all. So everything right now, they're still using newspapers. You're using newspapers and mail, U.S. mail.
That is the way the statute currently reads. The last time it was amended,
That's a new goal. Got a goal.
The last time it was amended appears to be 2002, according to the notes I have here. So certainly some water has gone under the bridge since then. And you are correct. And there are plenty of other statutory provisions that allow, for example, the defined term is statutory overnight delivery, which we know what that means. It's the companies that one uses to accomplish that sort of thing. But no, you're correct that the way this currently reads. Now it does then say, let me find myself. Mailed, transmitted by facsimile, or otherwise provided to the governing authority of any county.
Their question was based on the fact that they're still paying a good bit of money to do advertisements in the newspapers when their thought was that very few people see that.
Okay, so they're not as concerned with.
Sorry. Which one's is it on?
It's on, go ahead.
Oh, okay. Sorry. Well, anyway, they're concerned. So this is, I understand what you were saying with the code. I guess really what I wanted to know was if you thought there was any possibility of us relieving some of those outdated avenues with legislation.
Right. If the question is essentially, could this be done by posting on the website or what have you, that ultimately would be a policy decision for the General Assembly to make. Legally, there's nothing for me to comment on.
Good.
But you would say that as the author of the bill, that we would be wise to keep a copy of whatever form of notification we've given to the governing authority.
Absolutely. As my father-in-law, who's a dentist, says all the time, paper over everything. It will save you. Yeah, absolutely. I would. Is a wonderful idea.
So, okay, would you have,
Let's suppose something was done by a senator. They're going to do something, and they can do that. They get with them, it's done, So as it comes over, we can assume everything has been done properly, and we don't have to just go on with and have copies of all this. We're okay. We don't have to do anything else, do we?
So the bill's introduced.
Say it's introduced in the Senate. They do the advertising, have the affidavit. There's nothing, and we just have to sign off on it in the House.
So it passes in the Senate.
Passed in the Senate, comes to us. They bring it to us. We sign it. We assume. We just kind of, and that's a bad word, that it's been done properly.
I'm aware of no requirement.
Yeah,
that there will be some scrutiny that occurs in the other house.
That's because signing off, and because I'm assuming it's okay. Good. My partner here is taking care of us.
Thank you, Paul, for
Representative
bringing that. Could you repeat in regard to if the ad were to be, local legislation ad were to be run by a city attorney, a county attorney, or so forth? You mentioned something about 7 days, and I apologize for missing that. Maybe I'm the only one that needs to hear it. But my concern is that when I have a local county or city official and they say, we'll help you, we'll run the ad, and I don't want it to make it more of a lengthy process, a more complicated process. So could you go over those rules if someone were to run the legal ad for us in the legislature? What is the process?
And let me start by saying I believe it's very common practice, maybe even a majority of the time, for some local official to handle the actual running of the ad on our form, hopefully. The problem that can arise is if the ad runs and then the representative who's authoring the bill is not informed of that in time to provide the notice to the county or city or consolidated government governing authority. And again, that's only if it's an amendment to the city charter or the enabling legislation of a consolidated government or a county. Does that answer?
There's only two requirements, and those two are what? The last thing you said.
Well, step A is, will the local legislation modify the charter of a municipality or the enabling legislation of a county or a consolidated government? If the answer to that is yes, then within either 7 days after the ad runs or during the calendar week that the ad runs, the member who is authoring the bill must notify the local governing authority that the ad has run. Okay. Here's a copy of the ad. It ran on January 5th. That has to occur.
So if a city attorney were to run an ad and I get a copy of the ad, I've got to write a letter from my office back to the city to say the ad was run?
Yes. It's
which is basically documentation to say, oh, by the way, you ran this ad.
And that's what the point I was making earlier is. I know it can seem nonsensical, but that is the way the statute reads. Even though the city attorney, the city administrator handled running the ad, most assuredly the local government understands the ad ran. Nevertheless, a copy of the notice must be mailed, transmitted by facsimile, or otherwise provided to the governing authority of the county, municipality, or consolidated government referred to in the bill during the calendar week in which such notice is published, or during the 7 days immediately following the date of such publication.
You follow that, Brooks?
Yeah, if I remember correct, and clarify me.
Yes.
There got to be a little controversy a while back because I'm gonna run it for the city. I'm introducing legislation, but in Atlanta especially, the cost it got to be, that was a real controversy. I'm not paying for that. I'm your representative, because it got like $50-$60 maybe in Atlanta, where in Gwinnett maybe they ran it free. I don't know. And I remember at one time that got to be the real controversy. But it seemed like we've complicated it a lot more. That here it is. I have the affidavit. We ran it. Now I've got to write you a letter and say, I understand you ran it, and that's what you're. But I think it's gotten a little out of hand.
But Paul,
I blame us, not you. I blame us.
But this is not a new statute. I mean, this is not. I want everybody to be clear that. But it does say, you can send by email.
Yeah.
And you do attach, Paul. I mean, in Legislative Council, you attach a copy of the actual ad that ran. Is that not correct?
To the bill, yes. The
that
ad
is
and the
attached.
affidavit are attached to the bill.
Right.
But I'm afraid I'm violating because I'm not getting maybe that letter. I'm not getting that letter back. So it's got me.
We have another member that has had her mic on, so let me call on her, please.
I haven't been sending that.
Representative Bentley. Oh, she's over here. I'm sorry.
Thank you. I'm just curious to know bridge dedications, because I have to run a local advertisement for bridge dedications. Once before, I made my local government aware of the bridge dedication, and it just things didn't. At the end of the day, it didn't turn out as well as I anticipated. So the next time I had a bridge request, I just ran the ad and didn't bother to even talk to the local government. Sorry, Clint. But everything went smoothly. So my question is it a requirement for bridge dedications to when you run the local ads? Is it anything the local governments need to be a part of for bridge dedications for local?
If our office produced, and I say it this way because I'm new to the office and I'm still learning a lot, but if our office produced an ad, a local ad to be run, then the ad needed to be run. Yes, and then this notice requirement needs to be complied with.
Yeah, and that's what I did. I did all of that. I did everything that I'm required to do for as the state is concerned. I just, the first time I did include the local government in my plan, and at the end of the day, things just kind of went a way I didn't really want it to. And so the next time when I had a request, I just did everything that I was required to do on the state level, and I just did not include the local government until it was time for the ceremony. Yeah, so I just want to make sure that I was okay with what I was doing in that regard.
Well,
it sounds like I am.
If an ad ran and within 7 days or the same calendar week you sent a copy of the ad to the affected local government,
I did.
Then that would be compliant.
Okay.
Thank you. And we have a question from Representative Alexander.
Thank you, Madam Chair. And it's not really a question; it's just kind of a statement. But I'm walking on the tail end. But this is not new. I did it with my local legislation. I had to run an ad in the paper, and so I'm doing a bridge dedication also too, and I'm having to run an ad for that also. Yeah.
Okay. Thank you, Representative. Okay. Do we have further questions, or you have more to report?
Only, again, every ad has this information at the top. It's very good information. It basically restates what I just went over. The affidavit, signing that affidavit, you're swearing under oath. That is not something to be taken lightly. So, again, I just hope that's been impressed upon everybody, and that you will go back to your local folks and impress upon them the requirements.
Well, I appreciate your information, and I have been told more than one time that as you've stressed us today, that problems in the actual content of the ad can cause delays in you getting your local legislation through the process. So it's very important that you see Legislative Council and use the language that's recommended as you move forward with your advertising. I think it's I like the fact that we're signing off the new affidavit, and that we are responsible for everything after I am the author of the local bill to which this affidavit is attached. And so those two sections A and B are very important, and your signature is your word that you have indeed, and you will be held responsible for making for the content of that affidavit.
Absolutely.
So, I appreciate your time today. If we have no further questions, we'll close and we'll continue these discussions, whether it's with Leo or myself individually, or if you'd like more discussions as a committee, we'll be happy to arrange that. Okay, and we have one final question from Representative Benton.
Final question, Madam Chair, and thank you. Now, this is something a little bit different from the discussion right now, but it's regarding local legislation on our local calendar. I'm just guess I need a better understanding of. Sometimes I know that one time before I recall that we voted on everything on the local calendar all at once, and then I thought one time we split it up. Everything was. I thought I remember one time that we voted on the floor each individual item that's on the local calendar, and then I seem as though a different time that we voted for everything at one time, everything that's on the local calendar at one time. So how does that really supposed to work? Does it go all at once, or we do separate individual local? Because it may be something on the local calendar that I'm not supporting, but there may be something else on that calendar for dealing with local legislation I may be in support of. But we have to vote on all of them at one time.
I'm going to let Leo
Okay.
answer.
Yeah,
Thank you. Thank you.
Typically, we vote on the calendar as a whole, but every member has the right to make a motion to take one item off of the calendar and vote separately. So if there is one bill you would particularly like to vote no, you can make a motion to vote separately on that one bill and vote yes on the remaining calendar. And so that's probably what happened. Someone made a motion to pull certain bills off of the calendar and vote yes on the remaining calendar.
I follow you. Thank you.
And there is such a thing as local courtesy, courtesy to one another. It's not written in our rules, but if it's John Corbett's local legislation and it's been requested by his governing authority in his district and there have been no issues, he's done everything as he should, it would be a courtesy on your part to not object to his local legislation. Yeah, it's a good bill for John Corbett and his district, and who's to know better than John Corbett? Is there anything you'd like to say about that, Paul? I mean, I'm sure you've heard of local courtesy.
Nothing to add, Madam
Okay.
Chair.
Okay. Well, at this time, we will adjourn. Thank you for your attendance today.